Hello, hello, hello. This is Fox Trevize here. This is day 9 of the Kyle Rittenhouse Trial update. We have been with you for 10 days now. Even though it is day 9 of the trial, I came at you on day 0 when they did jury selection. This will be the 10th episode on this. What a crazy ride we've had. So, what happened today? Well, today was moderately uneventful. This will be a rather short show, even shorter than yesterday. Yesterday, I promised a short show, and I got it done in as little as 2 hours, which is now considered to be a short show for these updates. Today, I'm anticipating significantly shorter. We'll see. So, as we left off yesterday, there was a lot of discussion about what happens when you zoom in on an image. It's a big deal. As per our discussion yesterday, and as per the arguments by the defense, when you zoom in on an image of your dog or your family at Thanksgiving, it doesn't really matter what happens, what the computer's doing when you zoom in on something. Obviously, if you take an image of something and you're zooming in on it on the screen, something along the way is adding more pixels, because the pixels on your screen aren't stretching out, right? The pixels on your screen stay the same size. So if the image is getting bigger, then that means that smaller areas on the screen that used to be represented by a few pixels are now being represented by a lot of pixels. So where does the information to turn on and off those pixels or to add color to them, where does that information come from? Again, if you're zooming into a boop image of your dog's nose, or a funny, I don't know, like maybe your Uncle Dave spilled mustard on his t-shirt in the Thanksgiving photo and you wanted to zoom in on it to post it to the family thread to make fun of him, right? Where does the extra information come from when you enhance that image? Doesn't really matter for those situations. If you're like Kyle and you could go to jail for the rest of your life, all of a sudden, that whatever happens in the computer when you zoom in on an image, all of a sudden, that's really, really important. All of a sudden, if you're going to go to jail for the rest of your life, that's a big deal. If you pinch zoom on your dog's nose, not a big deal. If you pinch zoom on what the state is alleging you to be pointing a rifle at somebody and provoking them to come after you, and if they're right, you're going to go to jail for the next 130 years, that's a big deal. It's a big deal what happens when you zoom in on that image. All right, so that's where we left off yesterday. It was essentially indeterminate was the status. As we talked about yesterday, the state brought in a witness who was absurdly unimpressive in explaining how image enhancement algorithms work. He testified that he had no idea how any of those algorithms work to when you zoom in on an image. They have no idea what happens to the pixels. He doesn't know if they're different colors. He doesn't know if they're mixed colors. He just didn't know, even though he was supposedly the expert. Let's see here. So we move off onto today. As I said yesterday, I started streaming essentially the moment that the trial was concluded for yesterday. So when I streamed yesterday, I didn't have the benefit of all the lovely image analysis that Twitter has done on the image that the state is trying to zoom in on. Again, the image, and I actually have a small example of it up here on the screen, as part of a meme. The image on screen is allegedly, though I think it's not, allegedly Kyle pointing a rifle at somebody. Who that somebody is, the state can't say. In what manner Kyle's holding his rifle, the state can't say. What's even going on in there, no one can really say. That's what the state wants to believe, though. The image analysis has shown that it's a little bit problematic. We'll jump into that. We're going to first kind of go through the what happened in court today. So no witnesses today, just a lot of discussion, a lot of very fun and interesting discussion. So to start off with the state prosecutors dumping a snow job of lesser charges. The judge described it as, quote, a multitude of lesser charges. Why are they doing this? Well, funny enough, one of the state prosecutors, not Binger, the other guy, the Jack Posobiec is calling him lunch break, which, because he's rather large, I'm going to call him prosecuting attorney lunch break as well, just because I don't know what his name is. So lunch break actually conceded that the reason why they're bringing in these additional lesser charges is because he believes that a, quote, reasonable jury will acquit Kyle on the heavier charges. So some of the charges include murder, reckless disregard for human life, et cetera, and attorney lunch break believes that a reasonable jury will find that Kyle did not have a reckless disregard for human life, essentially conceding that he thinks that a reasonable jury will not find Kyle guilty on any of the things that the state is alleging that he's guilty for, and that if the state is not allowed to add in these lesser charges, then Kyle gets off scot-free and the state loses. Well, the state can't lose. It's the state. It's got to win, right? You got a duty to have the state win. So what are these lesser charges? So Kyle he's 6 charges right now. 2 of them are for murder. 2 of them are for attempted murder, essentially, or a reckless disregard for human life. The other 2, I can't remember exactly what they are, but they're not as severe, but they're pretty severe. So let's see here. So one of them is first-degree reckless homicide. Actually, 2 of them are first-degree reckless homicide. That would be for Rosenbaum and Anthony Hubert. First-degree reckless homicide is pretty big deal. It implies some kind of intent. And there's a lot of tests to determine whether or not somebody's guilty of a first-degree reckless homicide. There's a lot of things that need to be proved. For second-degree reckless homicide, which currently is not charged, for second-degree reckless homicide, there's less things that need to be proved in order to prosecute somebody for second-degree reckless homicide. So it is currently the state's belief that they have not made their case on first-degree reckless homicide, and so they are issuing additional charges of second-degree reckless homicide, hoping that they can get something to stick because they did so poorly in arguing their first charges. Now they're adding in additional charges, just hoping that the jury will say yes on something. I don't think that this should be allowed, and actually we'll see later on that it will be up to Kyle whether or not this is allowed to proceed in this manner. Kyle has the legal right to be charged with the charges that he was charged with. I said charged a lot. And Kyle has the legal right to reject additional charges and to say that if the state really wants to charge him with additional things, then they need to restart the trial. They could have done that earlier and they chose not to. So it remains undetermined whether or not Kyle's going to choose to do this or not. But the judge also had the option of rejecting the additional charges. Basically, the difference in the different charges would be the current charge of first degree reckless homicide requires that Kyle have a, quote, utter disregard for human life. Second degree reckless homicide would mean that Kyle only has a, quote, indifference to human life. So the difference there is in the severity of what Kyle's state of mind was. If Kyle had a utter disregard for human life, then he is first degree homicide. If he had just merely indifference to human life, then he's second degree homicide. Now, what does utter mean? I don't know. I'm not a lawyer. But basically, from my understanding here, is that it would be, if what the state is trying to do here, and I'll explain this a little bit more, but basically the end of my argument here is going to be, if what the state is trying to say here is true, then it means that self-defense is just impossible. Like, it means that there is no possible way to legally claim self-defense if what the state is trying to do here is true or is allowed or is representative of what the law intends. Then that means there is never going to be ever an argument for self-defense. It makes self-defense in a legal impossibility. So basically, first degree utter disregard for human life is that Kyle had some kind of intentional psychopathy disregard for human life, that there was some kind of maliciousness in his mind at the moment that he disregarded human life and shot his weapon. The second being indifference more fits with what happened. When Kyle on stand was asked, did you intend to kill Rosenbaum? Kyle replied that he intended to eliminate the threat, that Kyle felt threatened. He intended to defend his life was his first answer. His auxiliary answer was that he intended to stop the threat. Those are both appropriate answers to what happened. However, in a self-defense situation, your intent is always going to be to stop the threat, and that does require indifference to human life. Kyle was also asked in regards to the shooting of Anthony Hubert and Gage Grosswicks. The defense or the prosecuting attorneys asked Kyle, "You were concerned for your own life in that moment, weren't you?" And Kyle replied, "Yes," which I don't know. I guess the state thinks that that's incriminating, that you care about your own life. But basically what this has set up is that it seems obvious and logical that if you're defending yourself with lethal force, that you are at minimum indifferent to the life of the person attacking you. Your primary concern is your own life. Your secondary concern is to stop the threat. Your tertiary concern is the life of the threat. As is perfectly reasonable. Philosophically, that is morally and philosophically, that order of priority is perfectly acceptable. It is highly moral to have as priority your life, second priority, and the threat to your life, third priority, the life of the threat. That is perfectly fine. It is perfectly moral, perfectly philosophically justifiable. And it's, up until this case, it has also been more or less legally the correct priority of things. Now, the state is trying to flip that priority on its head, however. So, because when you're defending yourself, you have this low priority on the life of the person attacking you, you by definition, self-defense, you by definition are going to have indifference for their life. Really, it's the person attacking you who has indifference for their life, but they're forcing you to come to some kind of moral conclusion about it. Typically, that moral conclusion is going to be indifference for their life. And that's fine. It is for Kyle to have indifference about Rosenbaum's life in the moment that Rosenbaum is chasing him and reaching and putting his hand on Kyle's rifle with the intent of doing Kyle harm. In that moment, it is perfectly philosophical, moral, and possibly legally okay for Kyle to be indifferent about Rosenbaum's life. That is the point of self-defense. What the state is trying to argue is that, well, self-defense makes it proof positive that Kyle has a indifference to human life. Therefore, he's guilty of second-degree reckless homicide. Essentially, as the beginning of my argument stated, hopefully I was able to logically lead you down the trail back to the beginning here. If that's true, then that means every time you claim self-defense, you by default are guilty of second-degree homicide, meaning that you're by default guilty of having an indifference to human life. If that's true, then by default, every time you claim self-defense, you're always going to be guilty of being indifferent to the other person's life, which means that you could never claim self-defense because you're always going to be, as soon as you claim self-defense, you've immediately, essentially by Kyle claiming self-defense, he has admitted and pled guilty to second-degree reckless homicide. By claiming self-defense, Kyle has pled guilty to having an indifference for life. That cannot be. While it is true that Kyle had an indifference for life in that moment, it cannot be that he gets prosecuted on a law dealing with that, because again, it would make self-defense impossible. That is what the state is attempting to argue right here, and if that is allowed to go through, if that somehow gets set precedent, it's over. So at least in Wisconsin. But this is terrifying. And because there is this clear paradox in the law of self-defense, I said it a few days ago, and I will say it again. There needs to be, out of this case, there needs to be clarification in the law of self-defense. There needs to be. I've been calling for a national stand your ground law for a long time. I think that there needs to be more robustness in this. I think that the situation Kyle's in would come under a stand your ground statute. But I think they need to call it the Rittenhouse Act. I think that there needs to be out of this legislation, maybe called Kyle's Law, that clarifies your right to self-defense nationally. That it can't be that if you claim self-defense, well, now you've just admitted that you had a disregard for the other person's life. As we talked about yesterday, self-defense is inherently violent. Self-defense is inherently aggressive, and it has to be. Violence and aggression aren't inherently good or evil, but they are inherent to self-defense. And so it can't be that in claiming self-defense, you've admitted that you are criminally aggressive, criminally violent towards another person. That would just turn to dust the foundation of your right to bodily integrity, and your right to, I guess, exist in this world. It would allow anyone to do anything to you and you couldn't defend yourself. That would be catastrophic to our society if it was true that you are not allowed to defend yourself. It would just be catastrophic. And maybe I'm pulling more out of this than what really needs to be done. Maybe I'm making a bigger deal about this than what needs to be done. Certainly within Kyle's case, it's a big deal to him. But if it gets set as precedent that claiming self-defense immediately means that you've pled guilty to indifference to human life, then it's not just Kyle who's going to go away for life. It's going to be a lot of people who go away for life. That has to be legislated after the fact. I hope the jury can understand this. I hope the defense can make the case that this paradox cannot stand. It makes no sense. It would erode the foundation of law completely if that was true. Hopefully the defense can make that case. Even if the defense makes the case and Kyle gets off from this, if Kyle gets acquitted after all of this, which I still hope he does, there absolutely has to be legislation clarifying this, providing clarity to the public, and providing clarity to the criminal. The criminal needs to understand that it is legal for a person to defend themselves. If perhaps the law was more clear, and Rosenbaum had a greater understanding that someone has the right to defend themselves with lethal force, if Rosenbaum chases after them, maybe Rosenbaum wouldn't have chased after them. Who knows? Rosenbaum was a crazy person. All right. Let's see here. The judge, so basically in adding these second-degree reckless homicides, the defense's case for them to not be added was that basically that's covered in self-defense. You shouldn't be able to add these in because the argument that he's guilty of second-degree reckless homicide is the same argument that he's using to be defended by in self-defense. So it creates this paradox and it shouldn't be allowed. The judge said that he would think about it, and that he wasn't going to deny the additional charges outright, and that he's going to allow the jury to decide. Also, Kyle gets to decide. So as I said, after they went through, basically they spent the whole day going through different charges that the state wanted to add in. And at the end of the day, Kyle was asked, or at least informed, that it was his choice as to whether or not these additional charges were going to be allowed in. And what the judge explained to Kyle is, you've got these very high-level murder charges on you, and that's it. He does have some other additional charges that are unrelated, but basically those murder charges are the big ones, right? So the jury, what will sometimes happen, inappropriate too, I might add, but regardless, it is a thing that still sometimes happens, is that the jury will say, well, he's not guilty, but if we say that he's not guilty, we're going to get roasted by the public, by their family, by whoever, by the media. And so the jury will allow outside influence to affect their decision. And what they'll do is called splitting the difference. So if Kyle has Kyle's got 2 murder charges and 2 reckless endangerment charges. What they might do is say, well, he's not guilty by the evidence, but we don't want to get roasted by the media. So we're going to say that he's guilty on 1 count of murder and 1 count of reckless endangerment, and say that he's innocent on 1 count of murder and innocent on 1 count of reckless endangerment. They'll split the difference. Kyle will still go to jail for 40 years, but the jury will get to, I guess, sleep better at night, and maybe Brian Stelter won't roast them as viciously as he may have otherwise done. And so what the judge explained is, if there's not lesser charges, if the first degree is only thing available for the jury to charge him with, that the jury can either pick first degree murder or nothing, that they might split the difference. If, however, they have this lesser charge to fall back on, if Kyle's is instead, they find Kyle guilty on second degree reckless homicide, which carries a much lesser jail sentence, that instead of having to split the difference, they might be able to fall back on this lesser charge. And so basically what the judge was explaining to Kyle, and it shouldn't be, it really shouldn't be. It's kind of goes against everything that the legal system supposedly stands for, that this is what it comes down to. But basically Kyle can roll the dice and take 10 years in jail, or basically he can have a much higher probability of having 10 years in jail, or he can roll the dice and have a 50-50 shot at 40 to 80. So it's not exactly pleading down, but it's hedging your bets. It's hedging your bets in such a way that right now it might be 50-50 chance that Kyle gets 80 years in prison. If Kyle allows these lesser charges to come in, maybe it goes to 70-30 with 70% chance that he has 10 years. Well, would you rather have a 70% chance that you get 10 years, or would you rather have a 50% chance that you get 80 years? That's a really tough choice. I don't know. I don't know what I'd pick. I think that it's not exactly 50-50 that Kyle goes to jail for 80 years, though, because I think that the state has done such a poor job at making their case. However, what the judge was explaining is that it doesn't really matter if the state made their case or not. The jury may still find the need to split the difference and give Kyle a half charge, even though that's not appropriate given the evidence. Juries are weird. We will also remember, so we don't know if these charges are going to stay in the case or not. The judge is going to decide on it. Kyle's got some time to decide on it. They don't have to decide until Monday. The judge also will remember 2 days ago, after Binger severely violated Kyle's constitutional rights to remain silent, the judge said, Kyle's defense put in a motion to have a mistrial with prejudice. What that would mean is that the judge could just declare a mistrial with Kyle being off free, and with prejudice means that the charges would be dropped and the state would be unable to recharge Kyle with those same charges. So essentially, if the mistrial with prejudice is granted, then Kyle's just free. That's just it. It's just over. The judge at the time was going to sit on that motion. He wasn't going to confirm or deny it. The judge has the right to execute that motion at any time, even after the verdict is rendered. So perhaps one of the possible end games for this is that the jury comes back with a split verdict that Kyle's guilty of 1 count of murder and innocent on the other count of murder, and so Kyle only gets 40 years. Yay. What the judge can do is then say, I'm going to declare a mistrial, because that's not how this is supposed to work. And because it's a mistrial with prejudice, Kyle's free to go and doesn't have to worry about it ever again. That is one possible route. The other possible route is that the jury doesn't take the bait. They don't take the bait of all the shit Binger was crapping out all over the courtroom this week, and they say, no, Kyle's innocent. The state did not make their case. That is entirely possible. That's what the evidence currently shows. The state did not make their beyond a reasonable doubt standard that they've got. There's a lot of doubt in the state's case. So a reasonable jury, as the state even is concerned about, a reasonable jury may find Kyle innocent on everything. That's certainly what we're all hoping for, but it's possible it won't. If that happens and the jury finds Kyle innocent of everything, then the judge doesn't have to worry about the mistrial. Kyle's just acquitted and he's free to go. So there's still a lot of ways that this can play out. Hopefully, and what I think the judge is trying to do, the judge is trying to interfere with this as little as possible and allow the jury their chance. Is that appropriate? Philosophically, yes. Is it appropriate with my bias in this situation? No. I think that it's clear that Kyle's constitutional rights were violated. There's been no discussion on Kyle's Second Amendment rights. Very little discussion on Kyle's Second Amendment rights. But that's clearly being violated here in the state questioning whether or not Kyle has the right to keep and bear arms. It's not up for the state to decide that. The Constitution's decided that already. I think that the judge, with my bias in this case, I don't care how Kyle gets off. I think Kyle needs to be let go of this. If that requires the judge to just declare a mistrial with prejudice, so be it. However, I do think that for the broader narrative, the broader context of current events, I think it's good if the jury is able to go through the whole process without the judge interfering and the jury finds Kyle innocent. That would be, or the jury finds him not guilty. That's what juries find. Juries don't find innocence, they find not guilt. I think that would be best for the overall environment, but if you're on trial for murder, you're not going to really care about the broader context. You're going to care about you. And so my bias from the point of view of Kyle is I don't care what it takes. I don't care what the judge has to do. I don't care how it looks. Kyle needs to be dismissed from this case. Kyle needs to be found innocent or have the charges dropped or whatever it takes to keep Kyle out of jail and to keep Kyle from paying some kind of undue consequence for not allowing a child rapist to touch him. There's the two ways to look at this, like I said. So from Kyle's perspective and from my own personal bias, I really just at this point don't care what it takes. Kyle, the charges need to be dismissed. Whether it's the jury or the judge or a meteor, Kyle should serve no jail time for this. From the context of the broader narrative of society, it would be better for us all if this trial was allowed to go through the proper methodology, the proper sequence of events to come to a not guilty verdict. That would be best for us all, but what's best for us all might not be what's best for Kyle. Alrighty. There's another discussion about the charge related to Richie McGinnis. So I predicted all the way back on the very first episode that this thing with Richie McGinnis was going to be the thing that Kyle hangs on. So I've already made my case multiple times that Richie McGinnis, not that he shouldn't have been there, but that Kyle shouldn't have been charged with the responsibility of keeping Richie safe when Richie chose to be in the position that he was in. I've made that case multiple times already, so I'm not going to go through it all again, but I did initially predict that Kyle would be acquitted of everything except for the reckless endangerment of Richie McGinnis. I don't know if that's my continued prediction. I'm really not sure what's going to happen at this point. I do think that whatever happens, I think that Kyle's going to be found. I think it's going to be a straight verdict, meaning that I think that it's either going to be all or it's nothing. I think that Kyle's going to be found guilty on everything or he's going to be found guilty on nothing. I don't think that it's going to come down to nitpicking on one event or the other. I may well be found wrong on that, but that's my current prediction here. However, I still think that this Richie McGinnis thing is going to get Kyle hung up. So they have a bunch of additional charges related to whether or not Kyle recklessly endangered Richie McGinnis's life. The defense actually made a rather decent argument about this today, and Jack Posobiec had made the argument previously, and so he's calling it the Poso defense, and I agree. And that is that Kyle did not recklessly endanger Richie McGinnis's life because Kyle shot 4 times at Rosenbaum, and he hit Rosenbaum 5 times. There's 5 holes in Rosenbaum, and Kyle only shot 4 times. So to have really for Richie's life to have been in danger at that moment, Kyle would have had to be doing more of a spray and pray type situation where he was just firing randomly in the direction of Rosenbaum, and that might have recklessly endangered Richie McGinnis's life. But the defense is saying Kyle took aim, and his aim was good. He hit his target 5 times after shooting it 4 times. So the idea that there was a stray bullet that could have possibly recklessly endangered Richie McGinnis's life, well, that doesn't hold up because, Your Honor, his client has good aim. So I think that the Poso defense or the I've got good aim defense, the marksman defense would be another way to phrase it. I think the marksman defense is good. I think that holds up. And whether or not the jury will appreciate that distinction remains to be seen. I think that declaring that you didn't recklessly endanger Richie McGinnis because you had really good aim on the pedophile chasing you, I don't know how that plays with the jury. I know that it plays well with me, but I also have a dark sense of humor, so I don't know if a average juror is going to understand that. I guess it would the way that you listen to that explanation, whether or not you think it's true, is reliant on what kind of person you think Rosenbaum is. It's reliant on what you think Rosenbaum was about to do to Kyle. I think that the testimony thus far has probably appropriately biased the jury against Rosenbaum. I think it's been made very clear what kind of person Rosenbaum was throughout that night based off the evidence presented. I think it's been made very clear what Rosenbaum's intent was. Rosenbaum having specified earlier in the night that if he got Kyle alone, he was going to kill him. And another instance where Rosenbaum said that he was going to cut members of Kyle's group's hearts out. I think that that's been appropriately and sufficiently conveyed to the jury. And so I think that if you make the marksman defense to the jury and say, well, you guys know what kind of person Rosenbaum was. You know what Rosenbaum's intent was for Kyle because Rosenbaum already stated it. Now here's the argument that Kyle did not recklessly endanger Richie McGinnis's life because Kyle's aim at Rosenbaum was true. I think that might play. I think that might play. We'll see, but I think that might be a valid line of argumentation. It's certainly convincing. If you step back out of our bias, which we're clearly probably mostly biased about this, I think if you step out of the bias, I think it is compelling. I think the marksman defense, the Poso defense is valid. Let's see here. The reason why this even came up is the defense discussed dropping the charge. The state, I believe, wanted to add an additional charge related to this. And again, this gets into the first and second degree recklessness. Basically, what the state wanted to say was they wanted a lesser charge of reckless endangerment of Richie McGinnis's life. And the way the state argued it specifically is that you can't prove recklessness because Kyle had good aim. You might be able to prove recklessness if Kyle had bad aim, right? So you might be able to prove that in the second case where Kyle missed the shot with the jump kick man. So Kyle shot at jump kick man twice and missed both times. You might be able to prove recklessness there. However, I don't know that you can prove recklessness in the Rosenbaum shooting because Kyle wasn't reckless. He had good aim, and his aim was true. He hit his target 5 times after he shot it 4 times. So I don't think that that's reckless aim. I think that's really not reckless aim. And then it might be hard to prove that Kyle... It might be hard to argue that Kyle had reckless aim at jump kick man, given that jump kick man was kicking Kyle in the face at that moment. So I don't know that I don't know that recklessness holds up either. However, the state needs to have some kind of evidence that Kyle was reckless, and they currently do not, specifically in the Richie McGinnis case. So the judge, again, did not say one way or the other whether or not he was going to allow this charge to go through. It seems like at the end of the day, it seemed like he was going to allow Kyle the first choice on whether or not these charges were added, whether or not Kyle wanted to hedge his bets with a 70% chance of going to jail for 10 years against a 50% chance that he goes to jail for 80 years. The judge is going to let Kyle kind of take his first whack at making that decision. I can't imagine having to make that decision. And then based off what Kyle's decision is, the judge will further rule on whether or not he's going to add those charges in. There was another discussion about whether or not Kyle had the right to actually keep and bear arms that night. It was, again, the judge did not make a conclusion on it one way or the other, but the defense was attempting to have the charge of illegally carrying a firearm is essentially what the charge was. So there's been this theory that Kyle was not allowed to have the rifle. He was not allowed to be in possession of a rifle. That's what the left's theory has been. That's what the state's theory has been. It has been the defense's theory that Kyle did have the right to have the rifle at 17. So there's a law in Wisconsin that an 18-year-old or that persons younger than 18 are not allowed to have dangerous weapons, of which an AR-15 is. However, there is exemptions in that law that allow for a 17-year-old to have a 17 and 16-year-old to have a rifle. Now, the title of this exemption is related to hunting. However, as the judge pointed out today, the title of a law has no bearing on the content of the law. You can name the law anything you want. You can name it the puppy dog law, and maybe it's got to do with cats. Well, it doesn't matter if it's called the puppy dog law. If the statutes inside the law have to do with cats, then it has to do with cats. It's got nothing to do with puppy dogs, even though it's called the puppy dog law. So the law is essentially called the hunting exemption law. I'm making that up, but just for your purposes. The law is essentially called the hunting exemption law that allows for 16 and 17-year-olds to have rifles. And so the state is saying, well, Kyle wasn't out hunting when he was holding the rifle at 17. And the judge is correctly interpreting, and as a lot of us have been correctly interpreting, it doesn't matter if Kyle was hunting or not. It doesn't matter that the exemption is called the hunting exemption. The actual text in the exemption says 16 and 17-year-olds can carry rifles. The statute doesn't say 16 and 17-year-olds can carry rifles for the purpose of hunting. It just says that they can carry rifles. So it doesn't matter that it's called the hunting exemption. It could be called the puppy dog exemption. It doesn't matter. What is the text of the exemption? The text of the exemption is 16 and 17-year-olds can carry rifles, period. That's it. It doesn't matter what the context is. It doesn't matter what they decided to name the law. The name of the law is relevant. So the state is trying to bring into the courtroom that the name of the law has some bearing on how the law should be interpreted. And whether or not that was the intent of the legislators, it's not Kyle's fault that the legislators are sloppy at writing laws. That's not his fault. The letter of the law is that Kyle, at 17, had the right to keep and bear arms, at least a rifle that night. So what the defense wanted was for the judge to drop this charge that Kyle was illegally carrying a rifle. Now, some interesting stuff had happened during this discussion. Essentially, what the judge decided was that he was going to let the jury decide. I think that was inappropriate. I think that now the judge retains the right to decide later on, because it sounds like on Monday we're going to be doing closing statements and then probably send the jury off into deliberation on Monday night, probably coming back on Tuesday. So that's kind of the schedule for the rest of the trial here. So Possibly before Monday, the judge could make a decision that he's going to drop this charge. He said he reserves that right, but as of right now, he has not. However, he did concede that, well, it's Wisconsin. That's what the law is. You can't have the title of the law be the interpretation of the law. It is only about the statutes within the law, and the statutes within the law say nothing about hunting. They just say 16 and 17-year-olds can carry rifles. That's it. And so Kyle's a 17-year-old. He can carry a rifle. Now, the state made an interesting concession during this discussion in saying that the hunting exemption makes no sense, to which a lot of us agreed that the gun laws in Wisconsin didn't make a whole lot of sense. Gun laws in most jurisdictions don't make a lot of sense. They're meant to confuse you so that you just don't have guns or you don't use them in the way that you're allowed to do so legally. And the judge actually picked up on this, saying, well, if the laws don't make sense, you're the state. That's your problem. It's not Kyle's problem that the state's laws don't make any sense. It's the state's problem that the state's laws don't make any sense. Kyle is not obligated to just bridle himself because the state's laws make no sense, so he just doesn't do anything. No, it's on the state to clarify their laws. It's on the state, if their laws don't make sense, that's their problem. It's not Kyle's problem to just say, well, this law doesn't really make any sense. It could be interpreted this way. It could be interpreted this way, or it could be interpreted that way. So I'm just not going to do anything. I'm just going to be paralyzed in fear that I'll be prosecuted in something because the laws don't make any sense. That's how tyranny works. That's not how America's supposed to work. That's not how apparently the state of Wisconsin is supposed to work. And apparently that's not how you breathe. Excuse me. All right. So basically the state, like I said, they conceded that the laws make no sense. The judge says, well, be that as it may, that's the state's problem. That's not Kyle's problem. However, the judge refused to declare that one way or the other. And so as of right now, it'll be up to the jury to decide whether or not Kyle was in violation of carrying a rifle that night. However, it seems very clear from the letter of the law that, well, if it says Kyle's allowed to carry a rifle, that's the law. It's not really up for the jury to decide that. It just is the law. And it makes a big difference because if it's found that Kyle was breaking the law by carrying a rifle, that colors the other charges. That makes a difference if Kyle committed homicide while committing another crime of illegally carrying a firearm. As of right now, the only person that was illegally carrying a firearm was actually Gage Grosswicks. So I don't think that when you're looking at two people who one of them was legally carrying and the other one was illegally carrying, well, I don't know that Gage has really a case there that Kyle inappropriately shot him. I think that this is a point where the judge could have, I don't think, shown some bias. I think actually what's happening right now is that the judge is being accosted with accusations of bias. And so instead of doing the neutral thing, which is to follow the law and drop the charge, the judge right now is probably scared that public, and probably rightfully so, that public opinion will say, well, if you drop this charge, then that's a conservative bias. And the trial's, he's a biased judge. And so to prevent himself from being charged with bias, the judge is overcorrecting by allowing certain things that he otherwise wouldn't do if there was no media attention on this trial. And that's unfortunate for Kyle. Then the state goes into this really weird, again, today there was no testimony. Today was just the judge and the lawyers duking it out, essentially. The state tried to claim that there's a bunch of problems with the defense case because the defense didn't prove a bunch of different things about what Kyle did or didn't do that night. And the judge reminded the state that the burden of proof is actually on the state. So if there was an issue that never came up during the trial that the state wants to use as evidence that Kyle had murderous intent in his heart that night, well, if the defense if the state never brought up evidence that Kyle had murderous intent, and the defense never defended that Kyle had murderous intent, well, the state wants to just say, well, it's presumed Kyle had murderous intent then. And the judge says, no. You're entirely forgetting how our legal system in America works. The burden of proof is not on Kyle to prove that he did not have murderous intent in his heart. The burden of proof is on the state to prove that he did. So if it's an issue that just never came up in trial, then it's assumed Kyle has the benefit of the doubt there. It's not on Kyle's defense to prove that all of these things. It's on the state to prove that Kyle had all these things and the defense to respond to it. So this kind of back and forth happened on several different elements of the trial, where the state, to make up for their lazy case and their laziness in not bringing up these issues and not proving them, they've now tried to shift the burden of proving them onto Kyle's defense team. And the judge says, no, that's not how this works. The state has the burden of proof. There is no burden of disproof on Kyle. If the state brings up an issue, then the defense can respond to it. But until the state brings up an issue and tries to prove something, there's nothing for the defense to respond to. The defense is purely a responsive act. So if the state never attempts to prove Kyle had murderous intent, again, I'm oversimplifying the specifics here, but just for your purposes, it's not really important to go into every specific detail. But just in effect, what Binger was trying to say today is, well, the state didn't really Kyle never proved that he didn't have murderous intent. And really what Binger is saying is that the state was lazy in not offering that proof. So because the state has poor evidence that Kyle was murderous, they're now trying to flip the tables and say, well, since Kyle didn't prove that he wasn't murderous, that proves that he's murderous. And the judge says, no, that's not how our legal system works. If the state never proved it, the defense had no obligation to respond to it, and the burden of proof is on the state. Let's see here. This had to do with things like how long the barrel was. There was some discussion that the defense never proved the barrel was of legal length. That's not on them to prove. It was on the state to prove that the barrel was an illegal length. There was... the state said the defense never proved Kyle had a hunting license. First off, Kyle did not need a hunting license to carry a rifle. We've already talked about that. The law doesn't stipulate that 17-year-olds can carry a rifle if they have a hunting license. It just says that they can carry a rifle. But the state says, well, the defense never proved Kyle had a hunting license. It doesn't matter if the state didn't prove that. The burden of proof is on the state to prove Kyle didn't have a hunting license, and they never did that. They never even attempted it. The state never even attempted to claim that Kyle's barrel was too short. So these were just ridiculous allegations. Again, today was basically the defense today was essentially the state admitting that they have no case, and so they're going to throw in a bunch of extra charges to hope something sticks, and they're going to try to flip the burden of evidence onto the defense and claim that means Kyle's guilty. Let's see here. Then there's a bunch of discussion about jury instructions. So I'm not a lawyer or a judge, and this is an illegal channel. So my understanding of jury instructions is a little bit lacking, but I'll go ahead and take a swing at it. My understanding of jury instructions is there are technical interpretations of law where, for instance, the way the gun law works of people under the age of 18 are not allowed to possess dangerous weapons, but the exemption that 16 and 17-year-olds are allowed to carry rifles, the judge would give a jury instruction that explains how that should be interpreted. That the interpretation of that law is that this superseding law of persons under the age of 18 cannot carry deadly weapons, that is now interpreted to mean that persons under the age of 16 cannot carry deadly weapons. That the rifle exemption, that supersedes the original law, and that if the jury members should interpret that in that way, that would be a jury instruction. So there's all kinds of very nuanced details in how the laws interact with each other, especially because this is a self-defense case, and the self-defense law grants you a privilege to break other laws, because self-defense privilege would then supersede those inferior laws about, say, murdering people or causing them harm, or et cetera, et cetera, et cetera. So jury instructions are very important, because the judge will eventually explain to the jury in these jury instructions, this is how you are technically supposed to interpret this law when you are deciding whether or not the defendant is guilty of violating those laws. And because there's a lot of interplay between competing laws here, that's going to make a big difference. So there was a ton of discussion about various jury instructions that they wanted to have given to the jury. The Twitter handle at Self-Defense Law, which I've been following them a little bit throughout this trial, they have been, obviously, per their name, Self-Defense Law. They are legal people who follow self-defense cases. They tweeted out today that this was all very confusing, which is my interpretation of it as well. I think that the jury instructions the discussion about the jury instructions is probably ultimately undecipherable by non-lawyers, and so I'm not going to really attempt to go any further into that. What will be important is the ultimate decision as to which jury instructions are ultimately put forward, which we will find out presumably on Monday. So my understanding is that the schedule moving forward is that on Monday we will have closing statements from the defense and from the state. The judge conceded that they can each have 2.5 hours, and so the approximation is that the state will close for 2 hours, the defense will close for 2 hours, the state will make an additional half-hour closing responding to the defense's closing, and then this defense will have an additional half-hour to respond again, giving them the last word. And each side having a total of 2.5 hours to close out to the jury. This closing will be very important, because this will be the first time that this will be the second time since the opening that the lawyers will be able to speak directly and candidly to the jury and basically lay out what their case is. I'll be curious who speaks for the state, given Binger. When Binger talks, he hangs himself. That was evident during the questioning. So I guess we'll see who does the closing statements. I think it would be interesting to watch Binger hang himself for 2.5 hours, because the state has no case. And the more Binger talks, the more off-putting he is. And the more he talks, the more he'll be able to explain to the jury how he doesn't have a case. So I don't really know what he's going to talk about for 2.5 hours, but I will be highly fascinated to find that out. It is my prediction that attorney lunch break will be the one to do the state's closing arguments, but I don't know that for sure. After both sides do their closing, which should presumably take 5 hours, maybe 6 or 7 with breaks, at that point on Monday night, the jury will be sent off for deliberation. Will they come back Monday night? I don't know. Will they come back on Tuesday night? I don't know. Will they come back 3 weeks from now? I don't know. I suspect it'll be a quick verdict. That is my guess. Because it is my guess that this will be a quick verdict, because the evidence, the burden of proof on the state that there is some kind of beyond a reasonable doubt that Kyle intended to murder these people and that this wasn't a self-defense act, there just isn't any evidence. And so the jury is either going to very quickly come to that conclusion, or the jury had a predisposition to find Kyle guilty, and they will come back with that verdict. Either way, I think they come back with a verdict very quickly. Maybe less than hours. I believe the OJ verdict, I think it was like something like 35 or 36 minutes. It was ridiculously quick, and they thought that it was going to take 3 weeks for them to come back with a verdict. And one of the reasons why they thought it would take so long to come back with a verdict from the OJ trial was there was an unprecedented amount of evidence that the jury was supposedly going to be going through in the deliberation room. This case similarly has a ridiculous volume of evidence with all the video and photos. There's thousands of photos, probably hundreds of hours of video documenting an hour in time from 30 different angles. And I think that probably the jury won't be going through that very much. I think that the case has already been made or broken, and that they will come back rather quickly with that. But I could be wrong. Let's see here. The images I chose to have on the screen today. On the right side is a meme of Jack Posobiec doing the soy boys pointing meme, a version of that. He posted this last night when there was all that kerfuffle about the zoomed in image. And then funny enough, Posobiec's meme became a reality today, as we can see. Only he got the order wrong, but you can see Krause and Binger actually doing the soy boy pointing at actually the image that Posobiec made the meme about. So Posobiec is now constructing reality out of memes. I would not cross him. He's clearly a wizard, but I did think it was funny. The judge did make some comment about this blurry image, and I think I'll try to see if I can find some of the analysis. Basically, that was the end of the day. They decided they would, both sides were going to, do. I think they were going to call maybe one more witness on Monday, and then go into the closing arguments, and then they're going to go into deliberation. But that was basically the end of discussion today. Like I said, it was basically just everybody was. It was only the lawyers and the judge talking. There was no witnesses today. Let me see if I can find some analysis on some of these images here. We'll talk about it. Let's see here. Yeah, because other than that, that's all I got for you on the trial today. So I'll see if I can find some images that are of interest, so you guys can see the pixel interpolation that everybody was so hung up on. Let's see here. I suppose I can just show you guys me scrolling through Twitter. I'm on Posobiec's page, so I'm sure it's safe enough. Actually, this was a pretty good one. So this is the image that the state thinks makes their case, that Kyle is pointing a rifle at somebody. I'm not sure who they think Kyle's pointing a rifle at. I guess it's clear that that's Kyle from the video. That's not necessarily in dispute, but what Kyle's doing in that picture is not necessarily clear. The GIF here does a pretty good job of showing what that image shows. So it's really unclear what Kyle's doing here, but you do see some kind of dark line across his body. And what this GIF does is it takes a picture of Kyle holding his rifle across his chest and overlays it across this blurry image. And you can see, okay, that dark mark across Kyle's chest, that's in the same position of Kyle holding his rifle at low ready. But the state is trying to say, well, that's Kyle aiming his rifle at somebody. I guess unless they're on the ground, I'm not really sure how he would accomplish that. But this analysis here actually does a really good job of explaining with your eyes like what actually is happening there. Let's see here. There is another image. Let's see here. Trying to find the state's. Yeah, there we go. Okay, so this is actually the exhibit that the state has submitted to evidence. And ignore the lines here, but it does show that the original image on the right and the state's altered image on the left, those green lines do actually show people in the image leaning in different directions between the enhancements. So the state alleged that they had merely zoomed in on the image. However, you will notice, and I would encourage you to do this yourself. You can do an experiment. The judge actually did an experiment on his iPhone today that was rather compelling. He took a screenshot of a text message, and then he zoomed in on the text and showed that the text was blurry. That was actually rather compelling. But you can take a picture with your phone of a sign outside, right? And then you can pinch zoom in on that sign. What the state is alleging that they did was they did the equivalent of pinch zooming on this quadcopter footage of Kyle, and that's how they can see Kyle pointing his rifle. You will notice not the people in the image, but the sign in the background. So again, the image on the left is the state's quote-unquote enhanced image, and on the right is the original image. What is going on with that sign? When you pinch zoom something, it doesn't cause square signs to have these weird ghost images around them. And this is what Kyle's defense team really dropped the ball on. Kyle's defense team could have noticed this perhaps in real time yesterday, and they did not. Now, they were on the right track with the idea that there's pixel interpolation going on here, and that the algorithm is injecting additional colors and additional pixels into the image that were not actually there when the image was captured. There's a million ways that they could have gone on to explain that better. I think I did a relatively good way of explaining that yesterday. But this sign, you don't have to focus on what the people are doing. You could just merely show the jury, and hopefully they will do this in closing on Monday. But showing the jury the difference between the original, where the sign is this rather sharp white box, and then in the state's enhanced image, it has become this ghostly image behind it with some kind of sharp image in front of it. And so what's going on there? Now, you will also notice that, again, the people appear to be leaning. Now, you're not going to be able to see this on my screen right now. If you're watching along, you guys are watching a fifth-hand version of this image. It's gone through... first off, this has been modified by the state. It's been zoomed in. Then somebody pulled it off of a live stream from Court TV. And then they uploaded it to Twitter, and it went through the Twitter compression algorithm. Then I've got it on my screen, and it's being rescaled on my screen by Windows 10 and also Chrome. Chrome is interpolating it because I'm using Chrome browser. And then Windows is trying to interpolate it with the Windows NVIDIA drivers to get it to scale on my screen correctly. And then Streamlabs is picking it up, recompressing it, sending it to YouTube or DLive, and then the YouTube and DLive algorithms are then decompressing it, and then your phone's operating system is then reinterpolating what it's going to show you. I would encourage you to try to find, if you're interested in doing the image analysis yourself, try to find a more original source of it. Twitter, things posted on Twitter might be your better bet, but certainly if you're freeze framing the live stream I'm doing right now, you're not going to be able to do it. It would be nice if they would release the raw images to the public so we could actually do this. But there's other people who have been doing image analysis, and mostly what I'm doing is you kind of got to take their word for it. Things like the people leaning, I think I can see it. The stuff on the sign, that's obvious. That's really obvious no matter what you do to it. That seems to be obvious image manipulation. There's some other finer details about, you can see that this red light on the sides changed shape. You can see, allegedly, other people have said that they can see that there's people in frame that have been moving, that they're moved around and they're in different positions. And again, this is supposed to be the same frame, just blown up. However, it appears to not be. That doesn't appear to be accurate. So I don't know what the state did with this. Their image expert spent 20 hours more or less painting this picture. I think the defense has a really good way of arguing against this in their closing. However, it was revealed today that it appears the state's closing argument is going to be centered on this photo. This photo that their image analyst teased out of some kind of computer algorithm and then doesn't know how that computer algorithm works. Essentially what has been defined as a artist's rendition, that artist being the CPU, an artist's rendition of what happened that night, however, not an actual image of what happened that night. Is this going to be compelling for the jury? I think it could be. I think if the defense focuses on the sign being obviously ghosted and saying, the sign's huge, and look at what their image manipulation did to the sign, and then say, how could you possibly trust it's Kyle, who's, at least half the size of that sign in this image here? How could you possibly trust that they're not ghosting him in some way too? Because look at how many pixels that sign's being ghosted. And the state is saying that, well, if Kyle's rifle's down a couple of pixels, then that means he's pointing it at the ground. If it's up a couple of pixels, then he must be pointing it at somebody. But you've got several pixels on the sign here that are all blown out. So what's going on there? I think that the defense can make their case there. I think it's fine. However, I think the defense should have been prepared to make this case earlier on and not allowed this image to be admitted to evidence in the first place. I think the judge should not have allowed this image to be admitted to evidence in the first place. And I think that in theory that this could have actually set some precedent for what happens with digital photography and digital image manipulation in trials. Because like I said, if you zoom in on your dog's nose to make a boop picture, that's cute and adorable. If you zoom in from a block and a half away on what is going to make or break your murder trial, I think you got a lot more. It's a lot more important what the computer's doing when you zoom in. What's interesting here too is the state tried to portray this as pinch zooming, and you can see that in their version of pinch zooming, you get this weird halo around the sign. However, when let's see if I can do it. I want to open this image in a new tab here. When I use Chrome to zoom in on the sign over on the original image, you don't get any kind of weird haloing around it. You would assume that you'd as I zoomed in, there'd be some kind of ghost around that. Yet we don't see a ghost in it when I zoom in on it. However, when the state zoomed in on it and submitted their zoom as evidence, all of a sudden you get this crazy ghost around the sign there. I don't know. I have no idea. Also, I think that you can also see this this glint reflection. You guys can't see my mouse, unfortunately. Let me see if I can. I'll just explain it by zooming in on it. This weird glint in the center of the screen here. If you look at that on the quote-unquote enhanced image, you can see it's very circular here on the original image. When you go over to the enhanced image, all of a sudden it becomes this weird streaky thing. I don't know what exactly they did to this image, but it was certainly more than pinch zooming, that's for sure. Alrighty, well, I could talk about this image for another 3 hours. However, I promised you guys a shorter show tonight, and I will keep my promise. Also, there is probably a lot of other people doing much better image analysis than I'm doing with just using my click wheel to scroll in here. What's going to happen, I don't know. I know for sure on Monday we will hear closing arguments, and the jury will go out for deliberation. I'm considering taking off Monday, and I might actually live stream during the closing arguments. I don't know if that's going to make sense or not. Makes sense or not for me to do that. If they do end up taking long breaks or long lunches, that might not be great for the continuity of the stream. So I will consider that. No promises, but I will certainly stream on Monday. That's for sure. And we'll actually, I don't know. Maybe I won't. How about this? If I'm not able to live stream during, do a watch along of the closing arguments, what I'm probably going to do is wait until Tuesday to review the closing arguments, because I want to make sure that I'm able to view the entirety of the closing arguments. So I'll either stream very late on Monday after all the closing arguments are done, or I'll wait to do that until Tuesday. And it's entirely possible if I wait till Tuesday to do a review of the closing arguments, we might have had a verdict already. So we'll see. I'll do my best to try and be as timely as possible, but no promises on that. All right, guys. You guys have a fantastic weekend. Those of you who regularly watch me for the Saturday weekly news recap, that will be taking place on Sunday. Taking a break tomorrow. So I will see you on Sunday for the weekly news recap. I will see you possibly Monday for another Rittenhouse Trial update. And then hopefully I'll see you on Tuesday for a verdict. Thank you guys for joining me in this. Been a wild, exhausting ride. And I will see you guys on Sunday. This has been Travis signing off. Have a good weekend.